All right, everybody, just going to quickly call the meeting to order and we will recess for another 25 minutes while members are in caucus. Thank you, everybody.
Madam Chair,
Hi, Senator Anwar. We're in recess
okay, thank you.
for
You have
half an
a,
hour.
okay,
So
thank,
I think pretty soon. I will text you as soon as we start, okay?
thank you, thank you.
Yep.
All right, everybody, we're going to get started with today's housing meeting. Welcome. As I always say, today is a good day to have a good day. We'll see how good it is. Any remarks by my co-chair or ranking members? Seeing none, let's get to business. Bills for review, item number 1. House Bill 5258, an act concerning tenant organizational activities. Is there a motion?
Motion.
JFS to the floor. Is there a motion?
So moved.
Second.
Moved and seconded. Any discussion? Senator Sampson.
Thank you very much, Mr. Chairman. If we could, as we've done in the past, would you mind just describing each bill briefly as they come up so that the people watching and the committee members at least get a sense of what's happening here through you?
Certainly, Senator. This bill is really getting at a couple of tenant organizations over the summer that I have witnessed, and I know in the past have dealt with some retaliatory actions from property owners. Not saying that this is indicative of all property owners for engaging in tenant organizational activities. Those things are, distributing leaflets or materials in the common areas, lobby areas, placing them under other tenants' doors, initiating contact with tenants, conducting surveys, posting information on bulletin boards, and assisting tenants to participate in what we call tenant organizational activities, basically getting together to talk about the quality of life that's in their particular property or sometimes their particular community, whether it be a group of properties. So this is just to extend a statute that we already have that says when somebody joins a tenant union, there are certain actions that may not be taken in good faith, whether that be evictions, raising the rent, fixing certain services within a unit. And that current statute gives them 6 months. This would provide an additional 4 months for those services in the dwelling units as well as evictions, but it does not, at this point, because of the JFS language, touch rental increases other than the 6 months that's already in statute. Any questions, comments, discussions? Senator Sampson.
Thank you very much, Mr. Chairman. I want to get into, the language of the bill in some specificity, but before I do, you mentioned out of the gate retaliatory actions that you've witnessed against some tenants. Can you describe what those things are through you?
Certainly. It could be something as simple as folks being in a community room in a building, and that community room is a room where people have meetings, they play bingo, they do these things, and they had a tenant organizational meeting that I was a part of. People came to basically tell them that they could not meet there, even though that is a place that is set for them to meet because of what they were speaking about. They didn't say that specifically, but many members of that group were then served with notices to quit. So, or given warnings from property management about some of the activities that they were taking. Not saying that this is something that happens for everybody, but it's something I've witnessed myself. Senator Sampson.
Thank you very much, Mr. Chairman. And do you have any direct, this is not a courtroom or anything, but I'm just trying to find out, to the extent that this is happening, how prevalent it is and how significant this incident that you're describing is. You said that some of the tenants were given notices to quit afterwards. Is there a direct correlation? Were they told that they were going to be evicted because they had this meeting through you, or is it possible that there was some other reason?
Thank you, Senator. It is certainly possible. There is some other reason. I would say that the circumstances during that situation seem to point to it not being so. And I know other folks who have either come to me or even members of this legislature who have attended some of these meetings have experienced similar issues. I'm not saying it's the most prevalent, but it does happen. Senator Sampson.
Thank you, Mr. Chairman. I also, by the way, I meant to say something at the start of this discussion, which is I wanted to thank the chairs for offering us a little bit of additional time today to review this language. Our agenda today, I think, has 12 items on it. 2 of them have substitute language, which was provided to us, at effectively the start of the regular scheduled meeting. So we did need a little bit of time to review it, and I don't want to complain too much that it wasn't enough time. In my view, if these things are so important particularly this is a subject matter we've heard about for the last couple of years. It really puzzles me that the bill could not have been drafted and distributed before the start of the meeting. And it just goes to show to me, that like when I really care about something, I've got it prepared in triplicate ahead of time. I'm walking into the meeting knowing what's going on and trying to make my case to people, not slapping it together moments before the meeting in some element of haste, and also making changes that, in my view, are somewhat significant. I don't even know where the folks that are behind this bill might stand on the changes, but we'll get to that in a minute. This bill, the chairman did a good job describing it, although I think a lot is left out of that description, which is what, in my view, is a very significant departure from the idea that some tenants might have concerns about what's going on in the building that they live in and wanting to get together to talk about it and maybe approach their housing provider or landlord about that. That makes perfect sense. I think most people in the world would say, oh, that could and should happen. But this bill has virtually nothing to do with that. And as we talk about it, you will see that this bill is not about tenants. This is not about housing requirements or quality of life or the quality of a rental unit. This is about union organizing. That's what this bill is about. It is all designed to allow strangers, effectively, to come into the lives of individuals and impact the arrangements that they have with their housing. And I'm not going to say that that couldn't result in a positive result for anyone, but I think it may have the impact of causing further problems in the housing market in Connecticut. The housing committee, we're supposed to be addressing policy that impacts housing in the state of Connecticut. And for me, that is, dealing with making sure that there's adequate and affordable housing for the people of our state, that set of circumstances that people are faced with day to day as landlords and tenants are something that they can work and thrive in as a policy, throughout the state's, codes and laws, so that, it creates opportunity for prosperity for all the parties concerned. And that, we have a legal system that protects the parties, that you could go to court if you had an issue with your landlord or you had an issue with your tenant, and you could be treated fairly and it can be adjudicated responsibly. I mean, to me, that's what the mission of this committee is. And in my view, the bill that is before us, House Bill 5258, an act concerning tenant organizational activities, it's not about housing, it's not about tenants, it's about organizing. And the bill belongs in the Labor Committee and not in the Housing Committee. And just to illustrate this, let's talk a little bit about the bill. The first thing I would like to ask, the first section, this bill's not particularly long, it's only a few pages long. And the first section looks to be mostly dealing with definitions. I'm just curious, Mr. Chairman, does this language in this bill apply to government housing as well as privately owned housing through you?
I do not think we specify that in the bill. Senator Sampson.
Well, I appreciate that it's not specified, but does that mean yes or no? Is government housing included? Would they be subject to the same requirements under this law to allow for tenant organizers and tenant organizations to exist and to do the activities that are mentioned throughout the language of the bill through you?
Sorry for the delay. It was just confirming. In some cases, it could. However, this bill would not supersede federal law. So, government housing that deals with, Section 8 vouchers and things of that nature would not be would not be subject to this. This would not supersede federal law. Senator Sampson.
Thank you very much, Mr. Chairman. I just want to say, I mean, I appreciate the response. I don't think that's a significant enough answer, though. I mean, when you say subject to government, federal law, I mean, I think we're all subject to state law and federal law, and therefore every housing entity, whether they are owned by the state, the federal government, or private entities, are subject to federal law. So are we saying that certain entities are carved out by virtue of their ownership? When you say Section 8 housing, does that mean that a landlord that owns a multi-unit building but has some Section 8 housing does not have to abide by this policy that is before us? Through you, Mr. Chairman.
No, Senator. What I'm saying is some people may be specifically carved out just based off of the rules they might have to follow based on whatever federal government either program or ownership they have, but it is not uniform across the board one way or another. Senator Sampson.
Thank you, Mr. Chairman. I don't know if anyone understood what you said. I know I didn't. I'm trying to find out who this applies to. Does this, New Haven Housing Authority, for example, they own a building. Do they have to allow these activities through you?
Yes, yes, Senator Sampson.
Thank you. And who would not have to abide by these or allow these activities?
I don't have any specifics for you. I think we can look into those, but as I said, I'm not sure what federal laws or guidelines govern every single type of government housing, so we'd have to look into those, but I'm assuming this would cover most housing. Senator Sampson.
Thank you again, Mr. Chairman. Yeah, so as I mentioned, the first section is really all about existing definitions that are in our housing code, defining dwelling units and landlords and so forth. Section 2 is a new section, and it defines some new terms. The first one being tenant organizer. And I understand there's a definition here, but I'd like to hear the chairman describe what a tenant organizer is through you.
Sure. I'll quickly just read the definition. It's an individual who assists in establishing and operating a tenant organization and organizing tenants to address the affairs of such dwelling unit or other dwelling units owned and managed by the owner of that dwelling unit or their agents. And it is not an employee or agent of such dwelling units' current or prospective owners, managers, or agents. Senator Sampson.
Thank you, Mr. Chairman. So based on that definition, could this tenant organizer be someone who doesn't live in the building through you?
Yes. Through you. Or yes, Senator Sampson.
Thank you very much, Mr. Chairman. Could it be someone that randomly is visiting many apartment buildings, looking for people to interact with through you?
Theoretically, yes. Senator Sampson.
Thank you very much. And I appreciate the theoretically yes, but as I go, I think you're going to find out that that's the exact point of this bill. This bill is not about those individual tenants getting together to discuss with their landlord issues that they have. This is about creating community organizers, in this case, tenant organizers, to go and effectively, stir up tenants and maybe create angst for all the parties concerned. I don't think it's going to work out like the proponents plan, that it's ultimately going to create a panacea of rainbows and unicorns. I think what you're going to do is you're going to create hostility where none currently exists, and I think that's a dangerous thing to do. What are the qualifications of a tenant organizer through you, Mr. Chairman?
There are no specific qualifications listed in the bill. It's a bill, not a job application. Senator Sampson.
Well, thank you very much, Mr. Chairman, but bills are the formation of policy that becomes law that we operate under, and people that serve in various types of professional roles, realtors, insurance agents, police officers, doctors, lawyers, they all have qualifications that are required not only within their profession, but sometimes by the state. And I'm actually kind of a person who doesn't really believe that this state license means a whole lot compared to certification from an organization that works with people in a certain business industry or activity. But when you say there's nothing specified, the answer to the question really is that there are no qualifications required. Am I correct about that, Mr. Chairman?
That is correct, Senator Sampson.
All right, thank you very much. Are there background checks required, for example, if folks are going to start entering into random apartment buildings throughout the state through you?
I'm not sure if somebody who either operates a volunteer tenant organization or a paid one has that in their policies, but it is not laid out in this bill. Senator Sampson.
Thank you very much. I appreciate you alluding to the fact that there's going to be paid tenant organizers as well. And I'm curious to know why there would be paid tenant organizers. How could they be paid and by whom? Through you?
When I say paid tenant organizers, I'm not saying that that is a requirement, nor am I saying that that might even be the norm. What I'm saying is that some organizations will come together, such as some of the advocacy organizations that we see in this building for many issues, to organize for many different issues or what they see as rights. And sometimes that comes with some paid either lobbyist, activist, or folks who do organizing work. So when I say paid, I just mean folks who are hired by some organization, probably maybe a 501c3, to engage in these activities.
Thank you very much. Would those organizations potentially be paid out of tax dollars, maybe through the form of earmarks in our state policy through you?
I do not believe that we pay tenant organizers in our current budget as it stands, Senator Sampson.
Thank you, Mr. Chairman. But is it possible that could happen through you?
I don't think it would be for the purposes of this, but yes, they could be paid state dollars.
Thank you very much. I appreciate your confidence, Mr. Chairman, but I have no such confidence. I, in fact, firmly believe that is the whole point of this. This is to create organizations that are going to come to the state of Connecticut and to ask us for money for what they consider to be a noble activist cause. But ultimately what's going to happen is taxpayers are going to be further burdened with more taxes to pay for further creation of nonprofit organizations that are doing nothing more than creating hostility between landlords and tenants instead of allowing these folks to work out their differences and use our current legal means. We have a structure. And if that structure, the housing court, et cetera, is not satisfactory, it's not working, then we should fix it. But creating advocates on the side of tenants for the purpose of coming around to various buildings and interrupting the flow of nature's course and business to create hostility, to me, does not sound like a very smart thing to do, particularly given the noble cause of this committee and where we stand in society today, which is that we need more available and affordable housing. That does not sound like a way to get it to me. That sounds like just another thing that is going to encourage people that are in the industry of providing housing in Connecticut to divest themselves of that risk that is growing exponentially every time this committee meets. The next paragraph refers to tenant organization. Can I ask the chairman to describe what that means through you?
Senator Sampson, tenant organization means an organization that is established by tenants of a dwelling unit or of multiple dwelling units owned or managed by the same owner or the owner's agent. It's established for the purpose of addressing issues related to the tenant's living environment, including the terms and conditions of their tenancy, as well as activities related to housing and community development. It meets regularly, operates independently from the authority of such dwelling units and the owner's agents. And before we continue, I heard you say that this bill is an attempt to create these tenant organizations, and just as the proponent of the bill, personally, just want to say that this is to support those organizations. They do exist. They are not things that we are trying to create, and they are folks who have gone through the various situations in which we try to protect for here. I know that I personally am not putting this forth to make sure that we are creating these organizations or creating a further discourse where we have tenants that are supported in spite of property owners or landlords. It is just to support those who are trying to improve and ensure the quality of life in their buildings. Senator Sampson.
Thank you, Mr. Chairman. I know you're a very sincere person and you mean what you say, But I have to disagree with you. You are, in fact, creating these organizations. You can say that someone is currently a tenant organizer or there is a tenant organization, but that is not the same thing as what this bill creates. This bill defines what those items are, and it creates policy that will be enforceable under our laws that gives them authority they do not currently have. So they are being created under this policy. They are not pre-existing. When we get to Section 2, small letter B, we're going to talk about the activities that these organizations are going to be able to participate in, which they cannot currently do. In fact, that's the purpose of the bill. We wouldn't have the bill in front of us. We don't need a bill to simply state tenant organizers or tenant organizations exist. You need the bill to pass a law to create some change in how our society operates and determine activities that certain people are able or prohibited from doing. And I want to correct myself. I just realized something, during this conversation, which is that I mentioned that tenant organizers have no qualifications, and I was mistaken because they have one qualification, and that is they cannot be associated with the owner, manager, or agents of the landlord. So that is the one qualification that they have, is that they have to be in opposition to the housing provider. I just want to make a small aside here. I serve on the Housing Committee and I serve on the Labor Committee, and I'll tell you, in my experience, basically what I witness coming from the majority, and again, I have a lot of respect for my colleagues. I think that they see the world differently. I think they have good intentions in most cases, but often they view the world as a antagonistic relationship between parties, where I don't think that's the way it works in most cases. Employers and employees do not have to be antagonistic towards one another. There's not always a battle between them. Sometimes those employers and employees are working in unison to better themselves. The employees knowing that the company does well because of their hard work, they will be rewarded. Companies rewarding their employees because they know that doing so will cause them to do better work. This is what happens. And the same thing happens in housing as well. Good landlords try and take care of their good tenants. They want their good tenants to stay, the ones that take care of the property, the ones that get along well with the other unit, renters. That works. And if there's antagonism created, generally speaking, it's because there are people stoking that. Let me just, address the tenant organization definition that the chairman just gave me. These tenant organizations are going to be established for the purpose of addressing issues related to the tenant's living environment, including the terms and conditions of their tenancy, as well as activities related to housing and community development. We already have that, okay? That is the activities of the landlord and tenant in their own negotiation, and it's also the housing court. If people have a problem, there is a mechanism. It already exists. This is not going to solve those problems at all. It will address them, which I'm happy LCO chose the proper term. If they thought it was going to solve things, they would have put solve. But no, they said address. Because effectively what's going to happen is they're going to address these issues and exacerbate them. That is what I expect to see happen. Also, the substitute language, which we're discussing now, which again was provided shortly before this meeting, makes a very notable difference, and that is that it eliminates from this paragraph the ability of these tenant organizations to include rent as part of their concerns that they might address. And I'm just curious, do the other proponents of this legislation agree that that should be omitted from this policy, through you, Mr. Chairman?
Well, I think partially this was done in relation to something that we will see later. I don't think that was necessarily the intent, but also you can go to your fair rent commissions to discuss these things if you wanted to discuss a rent increase. Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, no, frankly, we've had a lot of testimony in this committee. I remember being here past midnight last year on some of these housing things. And I got to tell you, I mean, the number one issue that we hear about is rent. We've already created fair rent commissions. And people that are concerned about whether or not their building is up to snuff as far as a public health concern or something like that, I mean, the resource for that ought to be the town. You have a building inspector, you have a public health department in every town in this state to address these things. We had a councilwoman here from the city of Bridgeport, and I asked her questions about, how they manage these things. She didn't have any answers for me. I mean, I don't mean to disrespect her, but I asked her how much of the budget is allotted towards taking care of building code violations or public health, and she had no answers. I mean, if somebody who's on the town council that actually determines the budget, sets aside the money for these various departments, doesn't know, then I don't know how it's being addressed. But that's what needs to happen. I want that to happen. If you're a tenant and you're upset about your situation, I want you to hear me loud and clear. I want you to be able to call the town building inspector and the building inspector come out and have the landlord make the repair that's necessary. That should happen. There's no reason why you should have to wait more than even a day for anything that has to do with running water or heat. That should be resolved immediately. And other things should be resolved promptly. That's what good landlords do. I mean, I think in most cases, a lot of these problems could be solved because people that have the means, they'll simply move to another place that is not giving them a hard time and making sure that the unit is nice. It just so happens that we have this small segment of the housing population in the state that is living in less than desirable housing, probably because of their own ability and means to be able to obtain it. And this comes up all the time in this committee. So it's the people that have the least amount of money, or they have bad job history, or their credit isn't so great. Those are the people that are struggling with these things more than anybody else. And I certainly recognize that. And they shouldn't have to deal with having problematic landlords or having their building in great disrepair. They shouldn't have to. They should be able to rely on the city government to resolve those issues. Tenant organizers, they're going to only add a desire for more money into the mix. That's what's going to happen. Nobody's going to come out and to your building and advocate on your behalf for free. That's just not going to happen. They're going to do it either because they're being compensated in some way, probably because they will come to this state government who will gladly hand them over money that will very assuredly not be used in the best possible way to address the concern. And that's what I have a frustration about. So moving on, I'm on line 72 if anyone's reading along with me. Oh, before I go there, I noticed at the end of the tenant organization meeting when we're defining what it is, under section C, it says meets regularly. I mean, that's one of the requirements of the definition. It's that this is established by tenants, owned or managed by the same owner or owner's agent. That's all it is. It's just a group of tenants suddenly become a tenant organization once they this bill passes, and that they meet regularly. What does that mean, Mr. Chairman? What does meets regularly? Is there a definition somewhere through you?
I don't think there is a specific definition of meets regularly. I think what would qualify is you have a set schedule that you meet quarterly, you meet every 4 months. That is a regular meeting versus some sporadic kind of organizing. Senator Sampson.
So if I was to say these tenant organizations meet whenever there's a problem that they feel that they need to discuss, would that qualify as meeting regularly through you?
Senator Sampson, I don't think that you can apply whether or not problems are regular or irregular without too much of an opinion. I don't think there's a factual definition of regular or irregular problems. So if it was based on problems, I don't think it would be a meeting regularly. Senator.
All right. Well, thank you very much, Mr. Chairman. Well, that creates a follow-up. When you say that just meeting sporadically, like when problems show up, does not qualify as meets regularly, does that mean that these tenant organizations would not have the rights that are listed here based on that through you?
No. They would meet regularly. They would meet quarterly. They would check in sometimes even when there wasn't a problem. But they wouldn't just do it arbitrarily based on whether there were problems or whether they just decided that this is when they were meeting. Senator Sampson.
Thank you, Mr. Chairman. I'll come back to it because I think we should talk about the activities that are involved now. Because I think once we talk about the activities that are involved, which again, I'm going to go back to my opening statement just as a reminder, no group of tenants got together and came up with this. No tenants, you said, we're having difficulty with our landlord. We should find a way to organize and we should petition that landlord to fix our building or what have you. That's not what happened here. This bill is about union organizing. And it's patently obvious to anyone who has spent time in this building or in politics what's going on here. And it's going to be more obvious as we talk through these activities. Because ask yourself as we go through them whether these activities have much to do with fixing anyone's building or addressing affordable housing as a larger goal. So under small b, under section 2, now it says an owner of any dwelling unit except those exempted from the application of Title 47, which is what I was trying to get at earlier. I still don't know who those entities are. I'm curious to know who is exempted. But those owners shall permit tenants, tenants authorized agents, and tenant organizers to conduct the following activities. So I just want to clarify that this absolutely means strangers, random people that may or may not have any direct acquaintance with the tenants themselves. This could be someone who comes in off the street on any random day. Is that accurate? Through you, Mr. Chairman.
Senator Sampson, I would say that is inaccurate. It says tenants, tenants authorized agents, and tenant organizers. So that means that the tenants or tenants authorized agents, which are folks who know the tenant, who the tenant has authorized, as well as tenant organizers together, which they would not be strangers to the tenants since they were appointed by the tenants. Senator Sampson.
Thank you very much, Mr. Chairman, but the language of the bill says otherwise. I mean, we may be parsing some terms, but the definition of tenant organizer, which I've already discussed with you, says an individual who assists tenants in establishing, operating a tenant organization, and so on. But it never says anything in there. There were no qualifications. You agreed with me. No qualifications, not even that they know the tenants or they're a member of the building. The only thing is they can't be related to the owners. So those people are now going to have the following authorities. One is they can come and distribute leaflets, in common areas, including lobby areas. Placing leaflets at or under tenants' doors. I don't know how many tenants that are listening to me really want to have strangers coming into their building, and that will be required by law to be allowed into your building, even if it's a secure building now. They're going to be required to be allowed to go into your building and slip stuff under your doors and leave out leaflets. And it gets better. They will have the ability to initiate contact with tenants. Even if you don't want to be bothered, they can start knocking door to door, conducting door-to-door surveys, posting information on bulletin boards, assisting tenants to participate in tenant organization activities. And this one I thought was really interesting from a perspective of, is this really about tenants and their well-being, or is it about union organizing or politics? What's it about? Number 7, holding meetings, including political caucuses or forums for speeches of political officials or candidates for public office, without the presence of the dwelling unit owners or such agent. That doesn't sound to me like some tenants getting together because they're upset about what's going on in the building and trying to find a solution. It sounds like an opportunity to create political organization and use this as a mechanism for politicians and political advocates who work with them to come into places they're not currently welcome. Because many buildings are restrictive because they want to protect the rights and privacy of the unit owners and or the tenants. Those are good things. This eliminates all those protections. Every one of those protections vanishes under this bill. It also says that these meetings, political caucuses, and forums with political officials or candidates, etc., shall be conducted at reasonable times in an orderly manner, held in any community room or recreation room, which is really owned by the owner of the building, if these rooms are open for the use of tenants or in common areas. It also says the owner of the dwelling unit or agent shall not require tenants, tenants authorized agents, or again, tenant organizers who could be people off the street to obtain prior permission before engaging in all of the activities that I just listed, including these political meetings. So, Mr. Chairman, what is this bill really about? Can you tell me how allowing these political caucuses, forums, and speeches of public officials or candidates without the presence of the owner in the building are going to help tenants resolve whether or not they're having repair done to their unit? Through you.
Thank you, Senator. This particular section is not about that specifically, but it also is not about amassing political power. I think what it's about is tenants being able to have these meetings, organize these meetings, and speak to folks who they would like to speak to in their place of living, their complex, without having maybe management who may or may not have a particular leaning one way or the other to tell people not to organize within the building or not to have those conversations within the building. It's just a conversation, and the organizers, the tenant organizers, or the tenants of the building are the ones that are asking for it to be had. Senator Sampson.
Thank you very much, Mr. Chairman. Again, I hate to keep disagreeing with you, but it is not the tenants. It is not the tenants. You could say it over and over again, but the bill doesn't say the tenants. It says the tenant organization, or it says the tenant organizer, which we established could be someone else entirely who is not a resident of this building, who has nothing to do with it at all. They can show up and have these meetings. That's what it says. There's more to talk about. I mean, Section 3, there are some changes, but I know my colleagues also have some questions about this proposal. If we wanted to establish some clarity in the ability of tenants to have redress for their concerns, I think we could do that. But I think we ought to be focusing on the tenants and their concerns. This bill doesn't do that, Mr. Chairman. This bill is about union organization. This is about political entities. This is about nonprofits getting taxpayer money. It's just it's a mechanism. This is how this works. I've been in this building long enough to realize. I watched a union come in from another state and take over daycare providers and people that receive benefits from the Medicaid waiver program without their asking for it, to basically force them into a union so that they could collect dues. This is just a way for an entity to be created so that there is another excuse to do political advocacy out in the world, to get access where access doesn't currently exist, and also to have it funded by taxpayers under the guise that this is helping tenants, when in fact all it would ever do, if the subject in the political caucus forum/meeting ever got around to the tenants, if that ever actually did happen, all that's going to do is create animosity between all of the parties. Nothing will be resolved. We have tools for these things already. We have tenants and landlords entering into private contracts as adults, as free citizens. That's how we operate in America. Free citizens get to make their own choices and engage in contracts and determine the terms of those agreements. If one party fails to live up to the terms of that agreement, they have recourse. In this state, landlords, they would have to pay a lawyer and go to civil litigation to do it. But tenants in this state, they can get help for free. The state pays lawyers to help people with all of these problems for free. I don't know what else you need to do beyond all of that. The towns are failing. Some of our large cities are not addressing these problems. The people that are supposed to handle public health, building code violations, they're just not doing it. That's why these buildings are in less than perfect condition. That's why those bad landlords that we keep hearing about are able to get away with it. Fix what we have. What you have is a perfectly good framework. It's just not being exercised properly. But that is no excuse to go down this road. This road is dangerous and fraught with more costs and less affordability for the average Connecticut resident. And absolutely not one single additional affordable home will appear as a result of this legislation. Less. That's what we will get. Less. That's all I have, Mr. Chairman.
Thank you, Senator. And before we get to Representative Zullo and Senator, if you would like to respond, we can do that after Representative Zullo, but I just want to speak to a few things that were said. One, I understand the tenant organizers can go into these buildings, but tenant organizers are part of tenant organizations. Tenant organizations are established by tenants of a dwelling unit or multiple dwelling units owned or managed by the same owner or the owner's agent. You also spoke about the fact that this is being painted adversarially, and I understand that there is some adversity in this. I'm not going to say there isn't, but when it says that somebody is not an employee or agent of the dwelling unit's current owners, or it says somebody operates independently, I operate independently of the New York Mets. I'm a huge fan of the New York Mets. If the New York Mets were going to move from New York, I would do everything that I could if I had the power to ensure that they stayed in New York. I am a fan of the New York Mets. I'm not an agent of the New York Mets. You can be a fan of your property owners. You can be somebody who supports your property owners and still be independent of them. So I want to make sure that that is abundantly clear. And the political representation that was given to this bill, I will just say, as the main proponent of the bill, the intention is not to give money to these organizations. It is just to give support. And if the money is something that will come, that is a conversation that would be had in appropriations. I sit on that committee as well. It is a conversation I would be having on either our conservation and development subcommittee or maybe judicial or wherever that would sit. But that is not a conversation that we are having today. The conversation we are having is just about the language before us. And I just wanted to clarify those things. Representative Zullo.
Thank you, Mr. Chair. And I don't want to jump ahead of the good senator. If they're in person and they'd like to go first, I'm happy to defer for the moment. It's up to you.
Fair enough. Senator Sampson.
Thank you very much, Mr. Chairman. And with respect to Representative Zullo, I don't want to beat a dead horse. I've said what I have to say. But I do want to go back to the language of the bill because that's all that matters. You know, we can have our opinions up here, but the bill is what I'm leaning on when I make my claims. Tenant organizers under line 75. Okay, it says that owners shall permit tenants, tenant authorized agents, and tenant organizers. Okay, so a tenant organizer could be anyone. We already established that in the definition under 1. They have all of these abilities. So I would suggest that if I wanted to go to a apartment building right now that is a restricted building, and it has a, you got to be buzzed in the front door, and there's a security guard on duty, and they do not allow political solicitation, et cetera, or whatever. I think that I could go there very easily and say, under this statute, you've got to let me use your community room, and I want to talk to the tenants. And there's nothing in this bill that says I have to talk to them about housing. I can talk to them about anything. We could talk about ICE. Through you, Mr. Chairman.
Thank you, Senator. And the only thing I will say to that is if we would like to provide language that further specifies that these tenant organizers would have to be accompanied by tenants of such building, I am more than happy to do that. Representative Zullo.
Thank you, Mr. Chair. Just have a couple follow-up questions, maybe a statement. In Section 3, and actually I'm going to focus exclusively on Section 3, it indicates that a landlord can't maintain an action against the tenant to recover possession of a property if within 6 months the tenant has done various things, attempted to reach out to a public official or filed a complaint, et cetera, et cetera. Does this also apply to actions to recover possession based on non-payment of rent, in your opinion?
No, it does not. And this is also what you are reading is Section 47A-20 of the general statutes. That's already in statute, and non-payment of rent is excluded exclusively from this, and the intention is to exclude it from any of these sections, new or old.
Okay. And that is, and you said under existing law, there's already whatever, notwithstanding language, or there's a provision under law that once this is incorporated in, would make it very clear that somebody couldn't just not pay their rent and then, you know, reach out to an elected official, you or I, for example, and say, hey, you know, I have a complaint about my building, in order to stall for 6 months of not paying rent and not being evicted, right? The way, if this were to pass and this were incorporated, you're saying that couldn't happen, right?
Yes, absolutely. I would also say that outside of the notwithstanding language, also I think if you're not paying your rent, that is a reason to evict somebody. It wouldn't be retaliatory at that point.
Okay. I don't know if at some point it might be necessary to just clarify it, add it for emphasis. I would want to make that abundantly clear, because I would not want to see bear out what I just described, that somebody is not paying rent and they, even if it's just for the purposes of muddying the water, cites to the section and says, hey, this isn't specifically called out, it's not specifically excluded. I would have a lot of concerns about that. So maybe we could take a triple look at it to make sure of that. The second thing that I wanted to inquire about is, are these periods of, we'll call it relief from an eviction, are they, can they be piggybacked? For example, on day one, I go and I contact my state rep and say, hey, I have problems with my building, or I file a complaint with my building inspector. And then on day 179, I file another one. Does that prevent, or would that prevent a landlord from maintaining an action to recover possession for another 6 months, in your opinion?
Uh, I'm not sure. As I said, this is current language. There was obviously accompanying language to this, so I'm not sure if that would roll. But obviously, the new language would do so, because that is following a meeting, and they can have multiple meetings.
I would just, I think there's a fairness element to this, and I hope that maybe you might consider this. I don't think your intent is to provide a never-ending stream of second chances and a never-ending stream of protection, such that the landlord would never be able to maintain an action to recover possession, as long as once every 179 days the tenant did one of these things and made note of it and put the landlord on notice of it, because obviously that would prejudice the landlord substantially. So if that's not the intent, and I sincerely hope it's not the intent, I'm hopeful maybe you'll work with us to make that clear in the statute, like, you know, maybe barring bad faith, you know, tenants cannot rely on this multiple times in the same year or something like that. That would be my only other suggestion at the moment.
Thank you, Representative. We will provide to all members kind of an overview of the original statute and what's excluded in it, because a lot of it would be kind of the same things that you would see included in our just cause evictions, for example. Any of those reasons to evict somebody still would exist, and I even think that I'm not going to speak on it, just in case I'm wrong, but we can talk about it for sure. The intention is not to give a forever loophole; it's just to stop retaliation. So any way to tighten this language, we can work on.
I appreciate that. Thank you, Mr. Chair.
Thank you, Representative. Any other questions from members? Representative Weir.
Thank you, Mr. Chair. I won't, the good senator covered many of the concerns that I have. Knowing you, so first of all, I listened to the description that you opened the meeting with, and I know that your intentions, I believe they're pure and true. And you gave a good description of your intent of the bill. However, listening to your description versus what I'm reading in the bill, it's two different things in many places, as I observe. And you know, to the extent that you know, I often make statements within this building that what we put on paper needs to be crystal clear, not just for us, but for anybody reading, you know, and going to have to act on this bill or the pieces of legislation that come out. And this doesn't, this is no reflection on you. This is a reflection of the bill and the language that's in here that is, in many cases, unclear to me. My colleague pointed out several of those. I'll probably refrain from a ton of questions. I'm just going to give you some examples how I see this. If we, page 1, line 4, section 1, subsection 3, I guess, dwelling unit. The way that that is described, to me, I interpret that that could encompass a housing authority in addition to a rental unit. This could be a nursing home, housing authority. You know, I can't imagine somebody wanting to do this with a hotel, but if there's a long stay residence inn type thing, any house or building or portion thereof which is occupied or is designed to be occupied, or is rented, leased, or hired out to be occupied. I mean, you know, this could apply way beyond. Not that I agree with even the premise. This entire premise I disagree with, but if that we're going to give labor type protections to, you know, labor unions existed among workers who were being compensated to get equal protection and equal pay, and you could say fair pay for a fair day's work. You know, to me, they don't even, I struggle, I twist my brain to understand how we can have, like, how is there such a thing as a tenant union? These are people who come and go, conceivably. These are not somebody who's going to be with an occupation. We're not talking about labor law. We're not talking about those same type of protections, but they're trying to extend and grasp trying to extend these same type of protections to somebody who's paying for, not receiving compensation. You're paying for the use of this unit. So anyhow, that's a philosophical. I struggle with the legal.
Representative, before we
Yeah,
continue,
okay,
just
yes.
just to clarify one thing, because I do understand that our conversation earlier, myself and the senator, was a little bit wonky when it got to the federal ownership of certain buildings. There is an exemption of 47A-2, which exempts things like you were talking about, like hotels, nursing homes, things like that. Those are exempted already. Just to be clear, on line 72, it exempts 47A-2. I don't want people to get scared that we're making the Marriott do these things.
Well,
Continue,
okay.
Senator
Okay.
or Representative.
Well, I'll have to go into which ones are. So are we in agreement that, you know, housing authority would be encompassed in here?
It certainly could be.
Okay.
Representative.
So it's, I guess what I'll state without any reservation is that it has the potential to expand way beyond when we think about apartment units with a common area. You know, I don't want to say use your imagination, but there may be some things that are exempted, but there's a lot of things that we may not have even thought of that this could extend to. So I'll make that point. It seems to me, and I'm not an attorney, but on lines 19 through 22, well, first of all, landlord talks about the owner, line 17 and 18. And an owner talks about the right to present use and enjoyment. And, you know, there's a legal definition to enjoyment and right to present use, and it seems to me that that's a conflict with the fact that the owner has to allow these types of activities, especially when there's no, you know, that might, for a resident, for a tenant, those activities might be spelled out as to what rights or what activities are going to be permitted by the landlord. Nowhere, I would be guessing that there's no lease that says you have the right to bring strangers in here or appoint somebody as your agent, you know, a tenant organizer or anybody related to, you know, anybody who's not, you know, unless you're a direct guest of a tenant. It seems to me that that line, there's a conflict. Line 21, when it says right to present use and enjoyment, we've taken that away. That's not the definition of an owner. If we then say that that same owner has to grant rights to somebody who's not paying rent, who can just come in any time, well, reasonable times. Would also like to point out, my colleague talked about tenant organizer and qualifications. He did mention, you know, hypothetically that tenant organizers don't have to go through a background check. And in a lot of cases, residents do. And so in some cases, you could have a tenant organizer who's a sex offender, child molester, with no background check, being able to be walked right into a common area by merely stating or being part of a tenant organization. I mean, we have and I look to the worst case scenarios, right? But this doesn't address the worst case scenarios, so that's on us to point them out, what could happen. I think it's incumbent on us to be asking these questions and not paint these pieces of legislation so broadly that leaves a gaping hole to have a sex predator under the guise of a tenant organizer having full access to any building, common areas, leaflets under, I mean, it doesn't say what could be on the leaflets. Lord knows what could be on those leaflets going into and under the doors. Yeah, I think my wife volunteers she volunteers driving elderly and disabled people to doctor's appointments. She had to go through a background check to be in contact with these people. Boy Scouts, Red Cross, whether volunteers or paid, have some sort of background check, and we've not spelled any of that out here. We don't know. You have no idea who we're granting access to these areas. And it's just appalling that it's almost like we've granted carte blanche. You know, if I was a bill collector or the police looking to talk to somebody, I would go up and knock on the door and say I'm a tenant organizer, because I'd have a better chance of getting in using this legislation than I would showing my badge or my identification. Mr. Chair, I do have a few questions related to a tenant organization. To your knowledge, do members of a tenant organization pay fees or dues to be a member?
I do not know whether or not they pay fees or dues. I would assume not, but I don't have that answer, Representative.
Thank you. And do we know if these organizations have to be registered with the Secretary of State or the Internal Revenue Service or any other government agencies to acknowledge their legitimacy, as some of the labor organizations do? How do we establish that these are legitimate organizations?
I would assume that if they do not have legitimate employees or a nonprofit organization, that they would not have to register with the state, being if they were volunteer.
Okay. Okay. Do we know if they're required to have, I know my colleague, Senator Sampson, and you discussed, what does regularly meet when they're talking about meeting regularly in line 70. Are there any bylaws required that would kind of give the fabric and let people know what's expected of that organization?
That is not specified within the bill, Representative.
Okay. Thank you. I'll just say, I have a single-family residence, and I've been a resident. I've been a tenant, right, in a multifamily dwelling many moons ago, and I can tell you at the end of the day, whether it's me in my single-family home or a resident in a multifamily apartment building or a condominium, you name it, a lot of us get up, we go to work, we come home, and we want to be, I want to be left alone. Like, Lord help the solar guy who knocks on my door trying to, at 5 o'clock in the afternoon when I've had a long day. And we are inviting, we are disregarding the will or the desire, not even taking into consideration what the residents want. You have tenant organizers who are going to be establishing themselves with more rights through this legislation without even, the majority of tenants, my guess, the residents would not want somebody knocking on their door, would not want somebody putting leaflets under the door, taking up the common spaces where they might be playing, they might have an arcade there, I've been to some places where they've got, a pool table, or they play music, or a fire pit perhaps, or an area to congregate and hang out and not have to listen to political speak or politically motivated or union-driven agendas where people want to go home to that's their abode, that's where they live. So I want those on the record, that we have not given, this bill doesn't give consideration to those residents who just want to go home at the end of the day, who have no issues with the management, who are happy to be where they are, and now we're going to be potentially, their rights, they're going to have to stay locked in there in order to avoid this stuff. They're going to have to stay locked in their residence. I mean, it doesn't limit them to common areas could be the pool. So if somebody's lounging by the pool in a community that has a pool, now they're potentially going to be subject to somebody coming up and bothering them. So I'll leave it there. I think I've shared my concerns. This is overly broad, and when we get overly broad, we are asking for trouble. When we try to appease one set of constituents at to the detriment of another, and I think that's where this bill is going. So thank you.
Representative Corpus, before we get to you, just really quickly, one of the issues that you guys brought up is well-founded, and I think it makes a lot of sense, and it might have been something that we overlooked, so I want to try to address it really quickly. Do I have a motion to amend Section 2, subsection B, lines 72 to 75? When it says an owner of any dwelling unit except those exempted from the application of Title 47A pursuant to Section 47A-2 of the General Statutes, add any agents of such owner and any agents of such owner shall permit tenants or authorized agents and tenant organizers. After it says tenant organizers, can we strike tenant organizers and say tenant organizers accompanied by tenants of such dwelling? I know it doesn't solve the entire issue, but it does get us to a place where tenants of the actual building that we are talking about are involved in these activities, and the tenant organizers are not the ones that are going around unfettered by any rules or regulations. Is there a motion?
So moved.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Oh, sorry. Any discussion?
Aye.
Any discussion? Senator Sampson.
Thank you, Mr. Chairman. I would support this amendment. It does go a long way to improving the bill, in my view, to make sure that at least there is a singular tenant that resides in the residence that is part of this activity. So I would certainly suggest my colleagues support it. It does make the bill better.
Thank you, Senator. All those in favor signify by saying aye.
Aye.
Those opposed,
Aye.
nay. Ayes have it. Back to the bill itself. Representative Corpus.
Thank you very much for that amendment, Mr. Chairman, because I think it improves the bill, but it also, I really appreciate that this is a work in process and that you're listening to our concerns, so thank you for that. A couple of specific questions. So we now have in current law, if you join a tenant union, you get protected for 6 months. You can't be there can't be retaliatory action which a landlord kicks you out of the building for. But this bill is now giving us a whole other set of activities which are sort of leading up to joining a tenant union, if you will, that protect you for 4 months. Is my understanding correct?
The only thing that I would disagree with is it wouldn't be leading up to the tenant organization. It would be after it is established. But it does include those activities. But those activities only apply in the underlined final lines of the bill and are 4 months, and it does not include rent increases as the original statute does.
Okay, thank you. Is there any standard of materiality on the list of kind of new activities that get protection, distributing leaflets, placing leaflets, initiating contact? Could you do it one time and be protected for 4 months?
Yes, but remember, and we will get the language to members, that the original statute is also protected in terms of there are certain reasons why you would evict somebody that are not retaliatory, and those are still allowed. This would just be for what was deemed retaliatory. And,
Okay.
and once again, would not include rent increases, just evictions or the lack of prompt services.
Okay, so the tenant is paying rent, but the landlord, the lease is up for expiration, and the tenant or the tenant organizer distributes one leaflet. Is the person then protected from being evicted from that property for 4 months?
They are protected from retaliatory evictions. They are not protected from an eviction period.
Okay. I agree with the questions of my colleagues, which said that these seem like pie in the sky examples, and I've encountered this in other committees here. It's really our job to anticipate every possible nook and cranny that people could exploit in the bills. It's the responsibility of lawyers drafting personal contracts, and it's definitely the responsibility of people drafting laws. So we need to be careful in how we draft these things, because we've had a lot of confusion on this bill, and I think that the suggestions that have been proposed would vastly improve it. Thank you.
Thank you, Representative. Representative Scott.
Thank you, Mr. Chair. Really quick, I think a lot, my colleagues have mentioned a lot of the things that we have. I do appreciate your ability to talk, and I know we'll be talking even after today and as this moves on. Because I do think there's a couple of things, that points we brought up that I think would be valid, that we could finalize the language. I know Representative Zullo brought some things up. We could just make sure it's clear, because I'm confused, and I know there's not attaching language, and that might have been part of it. That makes it a little bit confusing, so I appreciate that. I did want to bring up a piece of the puzzle, too, of really around lines 89 to 96, about the ability for folks to be able to use different rooms, organizations to use different rooms, and that literally the landlord, or they wouldn't be able to use in that scenario. They would not be invited into that place. They would not be able to go into those places. God forbid it was a laundry room, and the landlord lives in the building and wants to go use laundry. They can't literally go do their laundry in that scenario. Like that is they're taking it right away from someone else in the building because they can't go in there. So there's little things like that. How many people could be allowed in the laundry room? There's obviously fire codes and stuff like that. If there's 10 people out in there, but then there's 20 people in there, is the landlord allowed to say anything and do anything, or is that disrupting the process? I would think it's a safety standard, so he would. But again, things that are just, I do agree with Representative. We look at some of the worst case scenarios sometimes, and we need to make sure we're covering those when we're looking at that. So I think there's just some of these things. Again, I'm not going to be supportive of the bill in general, but I do think even so, the way it's written, I think we could just tighten it up a little bit and make sure that we're covering off and not letting some of these, what I would say, some holes in there. That could do it. I know you've spoken. You'll continue to keep working, and I trust that. So I'll end it there for that reason, and we'll have further conversations down the road.
Thank you, Representative. And I'll just say the laundry room language, when I saw that, I was a little bit confused too. But then I talked to some folks, and there's a reason, but we will continue to talk about these things. Any other questions or comments? Seeing none, I don't think I need to ask. We'll take this one by roll.
A motion has been made and seconded to JFS to the floor. Agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752. Representative Felipe,
Yes.
Senator Marks,
Yes.
Representative Scott,
No.
Senator Sampson.
Sampson is no.
Oh. Let me redo it. A motion has been made and seconded to raise agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752, as amended by amendment by A. Representative Felipe.
Thank you. We have to vote again?
I had to do the amendment.
Okay.
Representative Felipe.
Yes.
Senator Marks,
Yes.
Senator Sampson,
For real this time, no.
Representative Scott,
Representative Scott's a no.
Representative Roberts.
Yes.
Senator Gaston, Senator Anwar,
Senator Anwar votes yes.
Mr. Chair, I'm sorry to interrupt, just with a point of order. I apologize. The announcement from the clerk in the motion was a motion to raise. This bill has already been raised by the committee. I just want to make sure you don't have an issue with the way the wording of the motion is. I believe the correct wording would be, I'd like to make a motion to JFS to the floor as amended. Is that not correct?
That is correct. Christian, one more time.
thank you. A motion has been made and seconded to JFS to the floor, agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752, as amended by Amendment A. Representative Felipe,
Yes, yes, yes.
Senator Marks,
Yes.
Representative Scott,
Representative Scott's no. This is only one no, though.
Senator Sampson,
I heard Felipe vote 3 times. I don't know. Sampson is no.
Representative Roberts,
Yes.
Senator Gaston, Senator Anwar,
Senator Anwar votes yes.
Representative Brown,
Yes.
Representative Butler,
Representative Butler votes yes.
Representative Corpus,
Corpus votes no.
Representative Gonzalez, Representative Hall, Senator Hockedale, Representative Jensen,
Jensen votes no.
Senator McCrory, Representative Sweet,
Yes.
Representative Turco,
Yes.
Representative Weir,
No.
Representative Zulo.
Rep. Zula votes no.
Thank you.
We will figure out when we're going to leave votes open to, based on when we wrap up here. Next, we have House Bill 5259, an act concerning the education of homeless children and youth, JF, to the floor. Is there a motion?
Second.
Moved and seconded, as preempted by my good colleagues on my right. I will give us a small description of this bill. It's basically, there's a statute, McKinney-Vento, that we have in federal law, and we have a provision in our general statutes that kind of go along with it, but it currently says from time to time. We have a feeling that McKinney-Vento, which is a statute that allows children to stay in the schools that they are in or attend school when they are homeless. Right now, it says that it's amended from time to time. There is a fear that there may be problems with McKinney-Vento federally. So all we are doing is revising it to a date of December 23rd, 2022, when it was established, to freeze it in time for the state of Connecticut should anything happen federally. Any questions, comments, or discussions? Representative Scott.
Thank you, Mr. Chair. I do want to call out the idea of the precedent that we'll be doing today. We haven't really done this in the Housing Committee. It's maybe done in other committees or even on in the House or the Senate when we vote on bills in session. But to be putting things into state, codifying it in statewide when it's at federal, that could be very time consuming if you could think about all the different things that are different bills like this that are federal that we could do. I understand that there might be a thought process that this might be pulled out, but we're in session. We can do that at any point if that does get pulled out and we need to want to come back and protect it. So I don't mind looking at things when they are already, action has happened and made sure that there is something that's changed. This hasn't changed yet at this point, and I think it's a wasting, potentially wasting the time of us getting to the fact of, hey, we should be focusing on housing here. That being said, I'm 100% supportive of the idea, and I want to put that on the record, and I'll be voting in support of this to make sure that this does stay around for those folks, those kids who are going to be in a different school district, have the ability to go back to where their friends are, where their teachers are, where they've had learning before, that should happen. And we should make sure that stays happen. Hope it stays at the federal level. And I know now we'll have it at the state level here coming up soon, but I just want to make sure that is ability to happen and continue to keep happening. I do have one quick question though, through you, Mr. Speaker or Mr. Chair. How does the allocation of funds in that scenario where kids, 2 towns over, but still going to stay in the original school district they were, who's paying for that transportation or that ability to get that student back over to that school through you?
Representative, any school that has a child at it is required to provide them transportation regardless of where they are. And in terms of the money coming from either us at the state via ECS, that would depend on where that child was on October 1st of that year.
Thank you for that explanation. I appreciate it. And that's the only question or comments I have on that.
Thank you, Representative. Any other questions or comments? Seeing none, take the vote by roll.
A motion has been made and seconded to JF to the floor. Agenda item number 2, House Bill 5259, an act concerning the education of homeless children and youth. Representative Felipe.
Yes, one take.
Senator Marks.
Yes.
Representative Scott.
Yes.
Senator Sampson.
Sampson is yes.
Representative Roberts. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes yes.
Representative Gonzalez. Representative Hall. Senator Hockedale. Representative Jensen.
Yes.
Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir. Representative Weir.
Yes.
Representative Zulo.
Rep. Zulo votes yes.
Thank you.
Thank you. On to item number 3, House Bill 5360, an act concerning domestic violence and tenant screening. JF to the floor. Is there a motion?
So moved.
Second.
Moved and seconded. As we've been doing, I'll give a quick synopsis. This bill is what we're trying to get at, and I'll be frank. I think there are ways that we can improve upon the language and figure out how to really get to this population. It is a population that I know certain members of this committee work with very closely, and I do think that this is a really important issue for us to solve, which is why we are continuing this conversation, making sure that this bill remains. But we also don't want to put any unfair burdens on these folks as well. I know that while this doesn't necessarily create the ability for folks to discriminate, I do think that there will be maybe more precautions people take when renting to these folks, knowing that they might have to forego a credit check, and that's what this bill does. This bill makes it so a landlord does not deny a rental application on the basis of credit history if the applicant is a victim of domestic violence, which I think it establishes people as victims for those people who they are trying to rent from, and I don't know if there's a negative impact to that, but we will continue to have conversations. I do appreciate the proponents who came to us with this bill and what they're trying to do, and I hope we can get somewhere with it, but I definitely want to get it out today. Any questions, comments? Representative Scott.
Thank you, Mr. Chair. I appreciate it. And I echo those sentiments. This is something that I do think we can continue to keep working on. I think the language isn't ready yet, but that's okay because the process is still going to be working on over the next 2 months we have left. I think there are some things we need to look at this, and I'll raise those now. A couple of the concerns, just so we have them on the record, but also so it gives us a to-do list to kind of work on that we can look at as we move forward. One of the things is CHRO. So CHRO already kind of really does a lot of this carry work for them. If there is some kind of something being held against them if the landlord knows. They can't do that. They can't make sure they can't have a victim of domestic violence be treated differently. And that's something that CHRO, it's in the statutes with CHRO, and they're able to do that. So something, I'm not saying that this doesn't do anything. I'm just saying that's a lot of the work is already done through CHRO for what this is trying to protect against. One question I do have, and this came up actually internally, we were talking about this, is a timeline. So through you, Mr. Speaker, or Mr. Chair, if there was a police report, if there was a letter of domestic violence, all these different things that triggers that they're able to be classified in this status, how long after that could that be used? So for example, let's say it was 2022, this happened. How long will that police report last that they potentially have bad credit? Is it in perpetuity? And I'm just asking the question, is it 10 years, 5 years? There's nothing I don't believe in this bill, but is there any intent to have a cap on that, or is it forever that they're able to have this status for themselves through you?
That is a very good question. I don't think we get to it in the bill, and I'm not sure if there are certain statutes that predict when or not a police report may not be available for public consumption. But yeah, there's nothing in the bill that signifies that.
Thank you. I appreciate it. I don't think so either. And I think that's another one of the conversations we can have as we walk out of this room tonight, to be able to have more of a conversation. We don't want landlords to be, any landlord, good or bad, whatever, should not be looking at domestic violence folks that are victims in any other way except for they're a tenant of yours, and you should be treating them so. But at the same point, it does, I worry about this being put a scarlet letter on folks. It does kind of scare me, and maybe some of the folks won't even speak up because they're afraid that they're going to now know that now they're a domestic violent victim. So we just need to keep working with the folks who brought this up to us internally here and see if we can get this language into a good spot in the next 2 months. What's now here is something I would not necessarily support. I'm going to support it today because I do want to keep it working. But again, I think there's just got a lot of work to do before we can get a yes on the floor if we pull it up.
Thank you, Representative. Senator Sampson, followed by Representative Butler.
Thank you very much, Mr. Chairman. Yeah, just following up on Representative Scott's comments, I think he covered most of this. Obviously, everyone here, I feel stupid having to make these speeches all the time. We all care about the environment. We all care about domestic violence victims. Of course we do. And, when we have bills like this, we're talking about a policy. We're making a law. We have to get it right. And as much as I, want to support victims of domestic violence, when you put a bill in front of me that is completely unfair, that misplaces the responsibility of certain actions and requirements in the wrong place, it's hard to support. This bill says a landlord shall not deny an application for rental housing on the basis of credit history if the applicant is the victim of domestic violence. Okay, I feel bad if you're a victim of domestic violence, and I feel bad if you have your credit impacted. But the landlord, he's got nothing to do with that. Absolutely nothing. That person is looking through their applicants, and they're trying to choose the best applicant. Now, should some other applicant be displaced as a result of the preference given to someone who is a victim of domestic violence with poor credit history? I don't know. That's a hard policy question, but that's what this bill would do. I just don't see it. If we want to help victims of domestic violence, then let's help them. Let's find another way to do that doesn't go ahead and make a third party that's innocent of anything responsible. And that's what this bill does, I'm afraid. Aside from the other, aspects of the language, which is we don't know what defines someone as a victim of domestic violence. I don't know if there's anything in the statute that makes it very clear. Do you have to actually have an adjudicated case where someone was criminally charged with something to be a victim? I don't know. Or do you simply have to identify as a victim of domestic violence, in which case then you'll have people identifying as victims of domestic violence all over the place, even if they're not, just so that they can avoid a credit check. I mean, we've got to think about the ramifications of policy. Representative Corpus was brilliant a few moments ago when she said that, we have got to think ahead about every potential way that a policy that we pass can be interpreted, used, or misused. Again, is there a time limit? If someone is a victim of domestic violence at 20, but then they have poor credit when they're trying to get an apartment at 75 years old, I mean, is that really relevant anymore? What if they had poor credit history before? I'll also point out that we passed a law, it wasn't last year, I think it was the year before, about coerced debt. I don't know if you folks remember that, but we actually passed a law. I did not support it, but it is a law in the state of Connecticut that if you are a victim of certain types of bullying, pressure, domestic violence from another individual, you can contact the credit bureaus and have the negative credit removed from your history. That's a law in Connecticut. And that's a mechanism that would address this exact issue, in my view. So as much as I hate voting against this bill, because I want to help, I do care. And what frustrates me more than anything is I don't want anybody using this vote against me. My vote is perfectly legitimate, has nothing to do with my desire to support victims of domestic violence. It is just inappropriate to make a third party, an innocent third party, responsible. And I just can't support it as a result. Thank you, Mr. Chairman.
Thank you, Senator Sampson. Representative Butler online.
Thank you, Chairman Felipe, especially for actually stating up front that you will work on some of the areas that need to be addressed to make this a better bill that will appropriately provide the victims of domestic abuse in an appropriate way. I'm 100% in support of what we can do for victims of domestic violence. I just have a couple of questions and a comment to actually clarify some of the language in the bill. As it pertains to subsection E, there's three criterias that a domestic violence victim can submit to show that they're qualified for this. The first item is straightforward, and after reading that, I would say if they could submit that, they would definitely qualify. The second two criteria is a little uh, kind of ambiguous. The second item is a police report, and a police report may actually present the case that you show excessive abuse and it really qualifies, or it may not rise to a level where somebody looking at it may actually think that it qualifies. So it may or may not actually show a determining factor there. And my question to you, Mr. Chairman, is the third item here. It states a couple of sections of um, uh, in our statutes, but I don't know what they are. Could you tell me what those sections in statute are in item number 3, subsection E?
We will pause in a second, Representative. I'm assuming those are protective orders, restraining orders, things like that. But Catherine will give us a more robust list in a second. Just hang with us for a sec. Representative Butler, would you be okay with Catherine getting you those definitions once we finish?
Yes, that'll be fine.
All right.
If it takes that
I was
long to
correct
get to
about the
them, I guess
protective
my
and restraining
question was
orders. I
in
just don't
good
know if there's
form.
anything else.
Yes, thank you. I would just say that I will be supporting this 100% and trusting that the areas that you said that you're going to bring forward to bring more clarity and an appropriate set of language to address this is going to be what's before us, once it makes it to the floor for us to vote for. So thank you very much, Mr. Chair, for the opportunity to ask these questions.
Thank you, Representative. Obviously, we want this to work, not just to pass. Any questions or comments from any other members? Representative Weir.
Thank you very much, Mr. Chairman. And I, speak from I've had family members and friends who have been victims of domestic violence. And in one hand, we have the victim of domestic violence. On the other hand, I have, we've got this piece of legislation that looks to protect that group of people and assist them, which I agree with that premise. I am struggling with the fact that we now make this the responsibility of the landlord, that I don't want to, we have caused harm, or we will be causing harm potentially to the landlord, and find a synonym for harm, right? We are going to be putting that landlord or housing provider in a position to be forced to offer housing on this condition, and I don't think that's the right way to go about this. I am open, if you're open to talking about other solutions, other ways to accomplish what this bill, I think, is looking to accomplish, and whether that means assistance from the state, some backstop, some guarantee to the landlord that, again, this doesn't address whether that prospective tenant has a credit issue running in parallel to the domestic violence situation. So I think if there's a way to assist the domestic violence person who's been the prospective applicant without harming the landlord, I would be 100% in support of this bill. So I will be a no today, and I sincerely look forward to at least investigating options where we can achieve the result where we find housing for someone who's been a victim of domestic violence without putting the landlord, kind of making them responsible for our decision. Thank you.
Thank you, Representative. The issue before us is not the policy. It's really the issue of financial abuse in these relationships, and any way that we can solve that, that helps everybody and makes it easier to pass, I'm willing to listen to and have conversations about. Any other questions? Representative Corpus.
Thank you, Mr. Chairman. This is a really big problem. Domestic violence is the #1 violent crime in Greenwich. It's a problem in every town in our state. And I really think we are responsible for the laws that don't adequately protect people that are victims of domestic violence. And there's a lack of enforcement in the courts about financial coercion and coercive control and financial abuse. The system often awards the deepest pocket, which is also a problem. And really that's on us. Like, we ought to look at this more holistically than just this one corner of it, which is an important corner, but just one corner of it, which is, where is this person going to live? I also think the timing element of this is really difficult, because not only do you not want the landlord to be liable if the domestic violence happened 30 years ago, but you want the victim to have an opportunity to restart and really not be tagged with that anymore. I know they're the ones that have to submit the paperwork to get this ball rolling, but there's nothing in here that says if a landlord thinks someone's a victim of domestic violence or ever was, they could still shy away. So I really worry about the scarlet letter on victims of domestic violence traveling with them their whole lives, even though they want to be past that. So I will be a reluctant no, but I think we should address this issue at a much more holistic level, and the onus is on us, not on the landlords of the state. Thank you.
Thank you, Representative. Any other questions or comments? Seeing none, vote by roll.
A motion has been made and seconded to JF to the floor. Agenda item number 3, House Bill 5360, an act concerning domestic violence and tenant screening. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott. Senator Sampson.
Sampson is no.
Representative Roberts.
Yes.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockadell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
Nope.
Representative Zulo.
Reb Zulo votes yes.
Thank you.
Moving on to item number 4. It's a Senate Bill 336, an act concerning housing. JF to the floor. Is there a motion?
So moved.
Moved and seconded. Any discussion?
I will explain the bill. Yep, Senate Bill 336. It is our dummy bill. It's the bill that we have in case something, that's what it is. It's in case something gets missed, which I did do my first year that I was here, a new chair, and I forgot to raise a bill for somebody, and it was a very good bill about veterans' graves, and we were very glad that we had a place to put it. So this is just to protect people. Sometimes 3 or 4 bills that are about the same subject can end up going into one bill. So although I understand that those in the minority don't like it, I did hear chairs on other committees that I sat with today that the rankings did actually support their bills because they too did see that at times it is necessary. So I hope you will trust that we won't abuse it, and there might be a time that you might even need it. And so I ask that you support this bill.
Thank you, Madam Chair. Any other questions or comments? Seeing none, take the vote by roll. Oh, sorry. Representative Scott.
Yeah, we had this situation last year with 5002. It was about 80 words. It turned into what we saw at 5002 and turned to 8002. I'll be a no. I don't vote for dummy bills, and we'll vote for when they get to the floor. Then we'll be able to see what's actually in them, and then we can decide if we're going to vote yes or no on them.
Thank you, Representative. Any other questions or comments? Seeing none, vote be taken by roll.
A motion has been made and seconded to JF to the floor. Agenda item number 4, Senate Bill 336, an act concerning housing. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
No.
Senator Sampson.
Sampson is no.
Representative Roberts. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockadell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
Representative Zulo.
Reb Zulo votes yes.
Thank you.
Thank you. On to item number 5, Senate Bill 339, an act allowing long-term rental of bedrooms in a single-family homes as of right. the Golden Girls bill. Jay, after the floor.
So moved.
Second.
Moved and seconded. Is there any
Want me to
I will
just-
let my wonderful co-chair give us a quick description, and then we'll get into discussion.
So yes, thank you, Chair. So this bill came to me from a few different proponents, and at first I didn't really understand why we need it. In New London, where I live, I think you can have 4 or 5 different people that are not related living in the same house. You know, I certainly have nephews that have roommates, nieces that have roommates, but I guess that doesn't happen in every municipality. And a lot of times it's the rental properties that can have more than one roommate, but it's not if it's your own home that you can't then rent out some rooms to people if you need to. So I think it's a great bill. It's up to 3 bedrooms. Is it 3 bedrooms? I believe it's 3 bedrooms. And it has to, the lease must be 6 months or longer so that we don't get into any of the short-term rental business. And the one thing that is missing from here is we want there to be a lease that will just automatically go for anybody that does want to do this. I am a Golden Girl. I do rent a room in my house to friends. I had a hard time paying the bills. Once I became a senator, when I was a nurse working overtime, it was okay. And she had to leave her apartment and was stunned. She's a daycare worker. And, you know, I said, yeah, let's try it. And, you know, I'm one of 8 kids. I had 4 kids in 5 years. I like a little excitement. And it's nice to have a person in your house. It's worked out beautifully. And, but I will say having a lease is very important. Just like when we heard here with Just Cause, that even when it's your friend, there still is that power struggle between the person that owns the home and the person that is paying the rent. And, you know, I'm a very empathetic person. I care about people, but there is always human nature. And so I think it's very important that we get that rental agreement, that lease part of it into this bill. I think this is a bill that will help a lot of people. I'm kind of surprised we actually need it, but we do need it. And so I hope we can all support it. Thank you.
Thank you, Senator Marks. Questions or comments? Senator Sampson.
Thank you very much, Mr. Chairman. Thank you very much, Madam Chairman, for the description of the bill. I just have one question, and that is I'd like to confirm for the record that this does not override any local zoning in any other way. Like, for example, if there was still a restriction based on, I don't know, the use of sewer or septic or maybe a parking situation, something like that, that local zoning would still prevail. I'm inclined to support this bill. I do think it creates more liberty for the property owner. I'm a local control guy, but the most local is the person who owns the house. They should have the most rights on how to deal with things. And so I'm inclined to support it. I just want to make sure that it is not in some way reaching too far into giving preferential treatment versus other homeowners in the vicinity. Through you, Mr. Chairman or Madam Chairman.
I can say it, yeah.
Senator Marks.
No, because you're renting out a bedroom, so the sewer, you're not changing any of the sewer zoning. The parking, I mean, if I was married, we'd have 2 cars, so I'm not married. I don't know how to really address that, except I don't know. But you know, I had 4 kids in 5 years. We had 6 cars at one point. So all old Volvos, real cheap cars. But they were, you know, you have to have the parking. So that's the only thing I don't know, Senator Sampson.
Representative Weir.
And to follow on that, Madam Chair, I guess if I can follow up a little bit, if it wasn't parking, something that would be considered a nuisance if, you know, if you had 2 bedrooms rented, but there's now 4 extra, you know, 2 couples and there's 4 extra cars and 2 people are parking in the street. That would be, maybe it's causing a hazard or a nuisance. Is that something that we could say that local control would have the ability, if there's a fire or safety code or an issue with parking where it's causing a trouble, where it could be argued it's a nuisance or it's a hazard? I hope
Well, if they had 4 teenagers, would it be a nuisance or a hazard?
Well, let me put it this way. If it's a nuisance for parking 4 cars, if it's a hazard for a family where there's 4 or 5 cars, then I would consider it a hazard or a nuisance for a tenant.
Okay,
Some
I don't know.
remarks.
There must be some kind of zoning laws about how parking is for people that live in a house. I don't know the answer to that, but it's certainly something that I'm not worried about with this bill. I'm not going to address it. I'm not worried about it, but I will find out the answer for you, because I am sure there is some kind of zoning regulations about how many cars. I don't think anybody can tell you how many cars you can have in your house, whether I can have 5 cars if I want to, right? I could have 5 cars if I want to, and nobody can tell me I can't.
If I may, so my point is, if 2 or 3 of those cars ended up in the street rather than on your grass, it might be considered a hazard. So if it's considered a hazard for a family who parked 2 of their cars in the street, no renters, then I would like to just make sure that this bill doesn't give special protections to somebody who's renting any more than if there were the same number of people living there. That's all.
No.
Okay, thank you.
Yeah, I would say that the fire code would prevail in that case, and I hope in the case of parking that property owners would be smart enough to not over capacitate their driveways. Any other questions or comments? Representative Gonzalez.
Yeah, I got a question. If this have to go through the same housing laws, like let's say after 6 months, I don't want them to stay wherever. Do I have to go through the same, like if they want to stay, do I have to go through the same eviction process? Everything's gonna be the same?
Yeah, it's a lease.
It's a lease, so everything's gonna be the
Same
same.
thing.
Okay, thank you.
Any other questions or comments? Representative Zullo online.
Thank you, Mr. Chair. Just briefly for a comment, if I may. I don't love the spirit of this bill in a couple ways. I like the concept that it's going to create more housing, or that it's intended to create more opportunities for people to have places to live. I don't like the idea of turning every single family dwelling into essentially a 3 or 4 family dwelling, because that's what we're doing. A single family dwelling is designed to be habited, right, by a single family. What you're doing here is saying now you could have 3 families, you could have 4 families in that dwelling. And I think people buy into their neighborhoods expecting them to function a certain way, and look a certain way. And I think this is going to create a host of safety and quality of life concerns. Rep. Ware raised a great point about safety, and to the good senator's point, you can certainly have as many cars as you want, but if your town has zoning regulations like mine, you can't park them necessarily, or other towns, you can't park them on your lawn. And if there's no room in the street, then they're either eyesores on the lawn, or they're creating safety hazards in the street. I see people maxing out their septic systems in ways that weren't anticipated. Granted, septic systems, are designed for certain bedroom counts, but that's based on them being occupied by a certain number of people. I think when you inject this many people in, you're now changing the way that those calculations are done. I don't think those systems are created to function that way, account for that. And then again, the good chair raised fire code. That's certainly a concern. I think this just paints a little too broadly, with too broad of a brush for me. I'm not necessarily opposed to the concept, but I'm a no today until we can maybe iron out more of those details. And I appreciate the opportunity to explain why.
Thank you, Representative. Any other questions, comments, or discussion? Seeing none, we take the vote by roll.
A motion has been made and seconded to JF to the floor, agenda item number 5. Senate Bill 339, an act allowing long-term rental of bedrooms in a single-family home as of right. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
Representative Scott's yes.
Senator Sampson.
Sampson is yes.
Representative Roberts.
Affirmative.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes yes.
Representative Gonzalez. Representative Hall. Senator Hockedell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
Yes.
Representative Zulo.
Rep. Zulo votes no.
Thank you.
Thank you. On to item number 6, an act requiring the collection of identifying information of non-resident owners of residential property. JFS to the floor. Is there a motion?
So moved.
Moved and seconded. So this bill is just trying to make sure that we can get to folks who are renting property, and if they are doing certain things, at least be able to either contact them or issue a subpoena if a subpoena is needed to be issued. Now, this JFS language, or even the bill before it, will not be the final version of the bill. There was an issue that the Connecticut Apartment Association had raised with collecting driver's licenses, and we thought that that was an interesting kind of concept, so we were speaking with them about how to fix that, and then the prosecutors came to us and said, basically, if you don't have that driver's license, how do you issue a subpoena? So we're going to try to parse through that issue. This is definitely a work in progress from here, but we can have our discussion today. But I promise you this is not the final version, and there are more things to consider as we go forward. Any questions, comments, or discussion? Senator Sampson.
Thank you, Mr. Chairman. I will spare the committee a lot of dialogue about the language of the bill based on your comments that this is a work in progress. The concept of making sure that we can identify non-resident owners of property is a perfectly good one. The bill is crap. I don't know how to put it any other way. It needs a lot of work. There's some real issues with what's here. It needs to be addressed. I'm going to vote no today, but you can get me to a yes, Mr. Chairman, if you work on this and do it right. I am behind the concept. Thank you.
Thank you, Senator. Any other questions, comments, or discussions? Let me look online really quickly. Seeing none, the vote be taken by roll.
A motion has been made and seconded to JFS to the floor. Agenda item number 6, House Bill 5161, an act requiring the collection of identifying information of non-resident owners of residential property. LCO 2819. Representative Felipe.
Yes, in anticipation of making changes.
Senator Marks.
Yes.
Representative Scott.
Representative Scott's a no.
Senator Sampson.
Sampson is no.
Representative Roberts. Yes. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockedell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
And Representative Zulo.
Rep. Zulo votes no.
Thank you.
Thank you. On to item number 7, House Bill 5160, an act appropriating funds to assist homeless persons. JF to the floor. Is there a motion?
So moved.
Moved and seconded. I'm going to give the description really quickly. This is our line in the sand that we've drawn a few times. I think it's fair to say that this is going to be a conversation that needs to be had in appropriations. We hope they have it in appropriations. But we want to draw a line in the sand that this committee wants to see $33,500,000 appropriated to the Department of Housing for programs to assist homelessness. You talk about cold weather funding, warm weather. You talk about some of the conditions that people are in. You talk about the rise in homelessness over the last couple of years. That we talk about rent all the time. The rise in homelessness outpaces that. And actually last year it outpaced it very well. So this is just an opportunity for us to kind of scream at our folks in appropriations. I said in appropriations, so I'm kind of screaming at myself, to do the work and figure this out, because this population has been underfunded for years. We got to a place where we were doing very well for this population maybe about 10 years or so ago. And then we decided that we were doing good enough that we should stop. And here we are with the problems that created. So I'm not going to speak too much further on it, ask for any comments or discussions, but this is, in my view, our line in the sand. Senator Sampson.
Thank you very much, Mr. Chairman. I will support this bill out of committee today, but I want to do that with some very clear context, which is that I am not at all satisfied that the simplified one sentence, frankly, bill appropriating money is going to result in money actually going to solve the homelessness crisis in our state, or that the money will even actually make it to homeless people. I don't want to point fingers or name any names. I will say that I've been doing some research. Folks that pay attention to what happens here at the Capitol may know that myself and some of my colleagues have been very focused on corruption and trying to concentrate on investigating where money goes, particularly money that is earmarked for non-government entities. We had testimony from some folks that stand to benefit from this massive, significant increase in funding if this actually went through at the $33,500,000 mark. And I asked them a number of questions during our public hearing about where the money goes and how much is spent on payroll and how much is attributed to the leadership of the nonprofit organization that delivers these services, et cetera. And I got very vague answers. So I decided to go digging on my own and start looking at some of the financial records and the tax forms, 990s, et cetera. And I got to tell you, I'm pretty shocked at what I found, which is that a very, very small amount of the actual money historically makes it to the hands of the individual homeless individuals. I bet most people listening are not surprised by that, but I think you'd be surprised by just how little money actually makes it there. The one organization that I looked at, their 990 shows that they received grants totaling almost $4 million. Their total revenue is around $5 million, which is so close to 80% of it is government funded. Their salaries and benefits for their staff and employees, CEO, et cetera, is close to $3 million. So 55% of the total budget is going to them, not going to the actual individuals. The amount of money that actually goes as direct assistance to individuals is $500,000, which is 9.7%. So doing that math, that is not a very good investment. So that, 10 cents on a dollar that we appropriated in the past on a much smaller dollar amount, frankly, made it to its destination. So, as I said, I'm going to support this. I'm very much behind providing assistance to people in our society that need it, but it needs to actually get to them, and there needs to be some sort of accountability. So if we do approve a significant appropriation, I would like it to come with a framework that says that there's some sort of accounting, there's some sort of audit process, and there's some way for us to know how this money is used. Again, I think that there are a lot of very good nonprofit entities operating in our state and across the country that do a lot of very good work. I have no doubt about that. I'm not trying to cast aspersions on all of them, but there are some of them that are just using the state of Connecticut and the taxpayers as a piggy bank. And they come and they take money from us in the form of appropriations, in form of earmarks, what have you, and very little of that money actually goes to its intended purpose, the way it's sold to this legislature. And we've got to do a better job of putting protections in place to make sure that the hard-working people back home in each of our districts who are struggling to pay their electric bills and pay for their medication and everything else, we're just making the situation worse for them by taking money. And if it's not actually going to the cause that it is intended, to me, it's I don't know. It makes me angry. Let's leave it there. So with that, Mr. Chairman, you have my support for this bill, with the caveat that I am expecting to see, at the end of the day, some sort of protocol and protection associated with the dollars that we do get. Thank you.
Thank you, Senator. Any other questions or comments? I just make the note that in a couple of the other funding sources that either this committee or this committee adjacent looks at, we do look at staffing levels, and that is something that I think is well-founded. I'm not sure if the numbers that you what the numbers that you spoke about were from or who they're referring to, but we should make it a point that unless you're doing counseling services or something that is predominantly staff, that your staff doesn't take the lion's share of the money. Any other questions, comments, or discussions? Representative Corpus.
Thank you, Mr. Chairman. I sit on appropriations with you, and I feel like there is hopefully a sea change going on in this building. You know, there's a lot of accountability measures that were put in. I put in a number of bills on appropriations accountability. I think the issue has been raised for the governor, and he seems to have an appreciation of accountability, an increased appreciation of accountability. And it's a really important issue, and I think that issue will be taken up in approps where we both sit. But sitting on that committee, I find it very shocking that there is things go through there without that. And then there are audits that are done about the money that we put out, but we never sit down as a committee and go through those audits where valid issues are brought up. So I very much support this concept, and I look forward to you and I calling for that accountability when we see it together in approps where this will go next. Thank you.
Thank you, Representative. Any other questions or comments? Representative Weir.
I echo the sentiments of my colleagues. I think the intentions are certainly correct. The problem exists, but I would question, where are these dollars going? So for today, I'll be a no. I want to flag it. I want to make sure that it's on my radar to watch this. I would love to be part of any discussion in terms of making this bill achieve the goals that I believe it sets out to achieve. Thank you.
Thank you, Representative. We really wanted an unanimity, but understand that people have their concerns. Senator Marks.
Yeah, I just have to say quickly that having worked with many of the people taking care of the unhoused, they work day and night, a hard job, people-facing job that is a very hard job with people in crisis all the time. I really have a hard time thinking that those working with who have chose their life profession as working with people that are homeless, unhoused, that they're the ones we're going to worry that are really being criminal or not being honest with the money that they get. So I'm an absolute yes, and to those that are listening and have are a little shocked by what they're hearing, know that you do have many allies.
Any other questions, comments, discussion? Seeing none, the vote will be taken by roll.
Yes, Mr. Chair.
Oh, Representative Butler.
Yes, thank you, Chairman Felipe. I was a little late. Please forgive me. I just had a quick comment on this. I agree with Senator Sampson's assessment of making everyone accountable for this. We have more than one initiative, more than one organization many of which have different ways of addressing the homelessness that we face in the state of Connecticut. So I think invariably we need to hold all of them accountable, not just because it's a fiscal matter, but we need to look at the number that we need to actually help find housing and to make sure that we're making significant gains in in that initiative. So for those reasons, I'm voting for this because this is too important. When we look at the people that froze to death over the last few months, if this isn't a priority in the state, I don't know what is. So I hope that the Appropriations Committee and everybody else who has a vote in this will support it. Thank you, Mr. Chair.
Wise words from a former chairman. Thank you for your words, Representative Roberts.
Thank you, Mr. Chair. Thank you. I just want to completely say in full support of this bill. Just to hear comments from all my colleagues, I understand their difficulties. I do also want my colleagues to know that it gets colder outside. We go through the governor's office, believe it or not, I co-chair the End Homelessness Caucus. We go through the governor's office each and every week just to see what the cold protocol weather is. If they're gonna put that in effect because it snows, that's an expense out of its own from this actual process. The 211s that people are homeless, they don't have enough people to work those hotlines. That's an expense out of this. The people that work for the services, response, prevention, they're not even able to get funding because federal funding is froze up. That's an expense out of this money. So just to hear that some people may be feeding other people's pockets, it only hits different when, a dead body is found in your city, frozen to death, or your community frozen to death, or your state, which is very wealthy. And that's why I'm fully supporting this. Not even just because I'm the chair of the End Homelessness Caucus, but just to realize, like, we live in a wealthy state and homelessness is a thing in Connecticut. So definitely truly appreciate my colleagues around, but I always want people to just open their eyes. It's not just nonprofits. It's more so your 211. It's more so reaching out to the governor's office to put in cold weather protocols, Ubers, hotels. It's more than just the money you guys may think is coming from a nonprofit organization. Thank you, Mr. Chair.
Thank you. And I will concur on the cold weather protocols. I think the last time I asked the governor, I said until Easter, and now we're going to have an ice storm, so maybe he needs to actually do that. Any other questions, comments, discussions? Seeing none, vote will be taken by roll.
And a motion has been made and seconded to JF to the floor. Agenda item number 7, House Bill 5160, an act appropriating funds to assist homeless persons. Representative Felipe.
Felipe?
Yes.
Senator Marks.
Yes.
Representative Scott.
Yes.
Senator Sampson.
Sampson is yes.
Representative Roberts.
Yes.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes yes.
Representative Gonzalez. Representative Hall. Senator Hockadell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
And Representative Zulo.
Rob Zulo votes yes.
Thank you.
Thank you. On to item number 8, House Bill 5162, an act amending an authorization of bonds for the Connecticut Housing Finance Authority. I will just quickly explain that this is allowing down payment assistance to be used, or to allow for their funds in this bond authorization to be used for down payment assistance. Excuse me. Is there a motion? Moved and seconded. Is there any discussion? Representative Scott.
Thank you, Mr. Chair. Appreciate that. So I'm just curious about, and I don't know if you know these details. So if you don't, it's totally fine. I'm just trying to wrap my head around the details of it. So this is the funds that were already bonded out in a total of $38 million. When was that bonding done through you?
That is a good question. I think that this was a May and June special session some years ago. I don't know if it was 23, but I think we can sit for a second and have somebody get that information for us. So here's my understanding of how this has happened. This was bonded some time ago in the total of $38 million. It's my understanding it has not been bonded since 2017, at least the rest of it, which is around $5 million. And this is just to allow the authorization of that remaining $5 million to be used for down payment assistance. Representative Scott.
Okay, so again, just to confirm, so of the 38, 33 has already been used from when it was originally bonded for back, whenever the date, 17, whatever it was. There's about $5 million left. Is that's my understanding?
Approximately, yes.
Yeah, again, approximately, that's totally fine. All right, and then what we're asking to do here is it was bonded originally for the Emergency Mortgage Assistance Program. That was originally what
Yes.
it was bonded for. Now we're asking to be also, which I think is a key thing, right? So it's not switching, it's and to be used for down payment assistance.
Yes.
And that's now CHAFA will have the ability to use the remaining $5 million if this passes through the two different sources, or not two different sources, but two different funds, way to get out.
They would have two different ways in which they could employ these funds, yes.
Okay. Will there, sorry, through you, will there be additional need for money? So since we're adding this new, so let me reframe that, pull that back. How much is used in the down payment assistance program right now? One of my ideas is like, are we going to use $10 million a year, and all of a sudden this $5 million that's left over is going to go through quickly, or is it something that's going to be dragged out for a little bit longer? And again, you might not know all these answers, but that's a question I'm curious about how that money's going to be spent.
Yeah, I'm not sure how it's worked so far. Obviously, this money has not been allowed for the down payment assistance program as of yet. So for it to be used this way, I don't know if they have any way of checking how quickly it would be used. I know that, for example, we have like the Time to Own program, and when that program is employed, it runs out very quickly, and I think that's around $10 million itself. So I don't know if this would fall under the same guidelines as that in terms of how much you could use per down payment, but I do know, as we discussed earlier, that this money has been sitting there since 2017, when the $33 million had already been bonded by then. So it's just kind of been in the coffers for 8 years.
Okay.
Representative Sampson or Scott.
One additional question is this is bonding money, so you're giving it to the receiver, the person who needs the money. There's no loan back payback. It's literally this money that's going to go to them to support this. Is that correct?
My understanding is that these are bonds, not loans. Yes.
Yeah. Okay. Awesome. All right. Thank you for all that information. I appreciate it.
Thank you, Representative. Any other questions or comments? Let's check Zoom real quick. Seeing none, the vote will be taken by roll.
A motion has been made and seconded to JF to the floor, agenda item number 8. House Bill number 5162, an act amending an authorization of bonds for the Connecticut Housing Finance Authority. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
Representative Scott will be no for now.
Senator Sampson.
Sampson is no.
Representative Roberts. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockedal. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
Representative Zulo.
Rep. Zulo votes yes.
Thank you.
Thank you. Next, on to item number 9. House Bill 5365, an act increasing certain housing unit equivalent points. Is there a motion?
So moved.
Moved and seconded. Oh, sorry. Excuse me. Even I make mistakes sometimes. House Bill 5365, an act increasing certain housing unit equivalent points. JF to the floor. Is there a motion?
So moved.
Second.
Moved and seconded. This bill, it does exactly what it says. It does. It adds certain point totals for different types of affordable housing, such as elderly units, ADUs. It also adds a quarter point for developing accessory dwelling units as of right. I know that's something that folks on my right might really like. It's something that I personally am supportive of today, but do have some reservations about. And I know other folks have reservations about that or this bill in general. There are conversations we will continue to have, but I know that it is the thought behind myself, the Majority Leader's office in the House, certainly that we need to do something to incentivize more building of affordable housing. Right now, a lot of places it's stagnated into this logjam that creates a situation where, I represent the city of Bridgeport. We build a lot of the affordable housing, and not that we will not take that charge and continue to do so, but I'd love to also have some market rate taxpayers to build our tax base. So I don't know if anybody has any questions, comments, or discussion. Representative Butler, online.
Thank you, Mr. Chairman. I have a couple of questions. First question is there any requirement for municipalities that actually are going to benefit from this to build any housing?
There's no requirement. Sorry. Do you mean, is there a requirement to build housing in order to get points? Is that the question?
To get points within this bill?
Yes.
Additional points that are within this bill?
Yeah. Yes and no. I think your current units that have certain point totals would also get the extra points, but in order to get points going forward, you have to. I guess sorry. The answer to your question, now that I understand it, is no. These extra points will apply to units that have been built already, but it will also apply to units that are built prospectively as well.
And is there any language in here that speaks to having towns actually submit plans for what they plan to develop for affordable housing?
That is not in this bill. That would be in a bill that we are going to speak about on Tuesday.
Okay, well, I just have a comment now, and that is that it seems to me that the language in this bill is just going to reward people without them actually doing anything. We're going to give municipalities extra points to actually towards their goal for moratoriums, but they're not doing anything to earn it. So I don't particularly care for that. If they were to build more affordable housing, I would be willing to double the unit assessments and credit for them if they're actually building something. But to reward them for not building anything isn't what we should be doing to encourage more housing to be built in the state of Connecticut. So at this point, I'm going to be voting no. And like I said, if they ever decide to build more housing, I'd be willing to give them very generous benefits in terms of a carrot towards reaching those goals. Thank you, Mr. Chair.
Senator Marks.
Thank you, Chair. No question, just statement. I did speak to Majority Leader Rojas this morning, and he did explain, you know, he's just trying something different to try to entice municipalities to build more housing at the 20% AMI. He understands that we might have to change we do have to change the ADU language. And still a work in progress. It's something new. I know many of my allies, I read, there were only 2 that supported this bill in testimony. One of those was Majority Leader Rojas. And many of my allies do oppose this bill, and I read their testimony, and I understand where they're coming from. So this is a work in progress. We hear everybody. I want all those voices out there to know we hear you. And I trust everybody. All we want is more housing in Connecticut, and we're all trying to do the same goal. So I'm going to vote yes for this bill and see what happens between now and when it gets to the floor. Thank you, Chair.
Thank you, Senator Marks. Any other questions, comments, or discussion? Sorry, I just lost all the participants on Zoom, but I don't think anybody's asking a question. Vote be taken by roll.
A motion has been made and seconded to JF to the floor, agenda item number 9, House Bill 5365, an act increasing certain housing units, unit equivalent points. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
Yes.
Senator Sampson.
Sampson is yes.
Representative Roberts. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes no.
Representative Corpus.
Corpus votes yes.
Representative Gonzalez. Representative Hall. Senator Hockadell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
Yes.
And Representative Zulo.
Rep. Zulo votes yes.
Thank you.
Item number 10, House Bill 5369, an act establishing a task force on the calculation of affordability in the affordable housing appeals process. JF to the floor. Is there a motion?
So moved.
Moved and seconded. This is exactly what it says. It does. It's just to look at the denominator in 830G. I think it's something that we've been talking about for a long time. I will say that there are some parts of this language that allude to us affirmatively having to change or fix the denominator. I would like to work on language that just says that we are looking at it. I understand that we may want to fix that, and it's a conversation that I've had with folks, and I may even support changing or fixing it. But I would like to, if we pass it on the floor, see language that just talks about us looking at it, and if we decide as a task force that we did not want to change it, we don't have to change it. And I would also say that the makeup in terms of appointments by which party, I think those are pretty much set in stone. It's something that we agree on this committee. But the descriptions of those appointments may change as we go forward, and I commit to working with both sides of the aisle to figure out what those descriptions actually are. Any questions, comments, from members? Representative Scott? Oh, Rep. Butler?
Yes, thank you, Mr. Chairman. And again, I'd be in favor of looking at this and possibly changing this. And I think the important initiative here is just to say that um, that we should encourage towns to build more housing. And if changing this denominator would say to these towns that we're going to actually reflect the formula to actually give you credit, I would hope that the towns actually express that they would accept that and build more affordable housing. For those reasons, I believe that the denominator should be looked at in terms of how to fairly apply the law to those towns that have a reluctance because of the current formula. So I will be voting yes for this because I think that we need to take a good look at this. And if there's something that we could do to be more fair, to encourage more affordable housing, well, I think we should very well do it. So thank you, Mr. Chair.
Thank you, Representative. Any other questions, comments, discussions? Seeing none, take the vote by roll.
A motion has been made and seconded to JF to the floor, agenda item number 10, House Bill 5369, an act establishing a task force on the calculation of affordability in the affordable housing appeals process. Representative Felipe,
Yes.
Senator Marks,
Yes.
Representative Scott,
Representative Scott's yes.
Senator Sampson,
Sampson is yes.
Representative Roberts,
Representative Roberts votes yes.
Senator Gaston, Senator Anwar, Senator Anwar, Representative Brown,
Yes.
Representative Butler,
Representative Butler votes yes.
Representative Corpus,
Corpus votes yes.
Representative Gonzalez, Representative Hall, Senator Hockadell, Representative Jensen, Senator McCrory, Representative Sweet,
Yes.
Representative Turco,
Yes.
Representative Weir,
Yes.
and Representative Zulo.
Rep. Zula votes yes.
Thank you.
Thank you. Item number 11, Senate Bill 152, an act appropriating funds for rental assistance program housing inspections. JF to appropriations. Is there a motion?
So moved.
Second.
Moved and seconded. Any discussion? Senator Marks.
Yep, just to quickly, pretty straightforward bill that's just appropriating $250,000 for additional inspectors. Now, when people have qualified for Section 8 housing, they often have to wait up to 4 weeks, according to the testimony, is how long that they need to wait before an inspector can go and inspect the apartment. So not only is it affecting the renters, but it's also affecting the landlords in where they're holding an apartment for those that have qualified for Section 8, waiting for the inspection, not knowing if they're going to pass the inspection. So this is this will help both the landlords and the tenants. Not sure $250,000 is enough, but that's where we're starting right now, and hopefully it can make a little dent in the problem.
Thank you, Senator. And just for the record, that 250 is intended to go to 4 building inspectors. Any questions, comments, discussion? Senator Sampson.
Thank you very much, Mr. Chairman. It's interesting that you mentioned 4 because I was told 2. Can you give me an idea how that money breaks down? $250,000 equals 4 people through you?
No, I'll just correct myself. It was 2. I was just thinking even numbers, I guess. Senator Sampson.
All right, thank you very much, Mr. Chairman. Yeah, so just for those listening, this bill is all about this process that occurs when someone who is getting a RAP voucher and they begin a relationship with a landlord. The first step that is required by our state statute is that there is an inspection done to make sure that the housing unit is acceptable for the program. And what's happened is over time, I believe the timeline for these inspections has gotten longer and longer. And this presents a problem for everybody involved because a tenant may meet up with a landlord, they might come to an agreement, that everything might be hunky-dory, but then now we're waiting on this inspection. The landlord can't let the person move in until the inspection is done, and time is going by. And you can't expect them to take forever and wait, for that approval to come when they might have other tenants that are ready to go that do not have to go through this procedure. So I understand the intent of this bill is to help resolve that problem. I just don't think that this is the answer. The fact is we're throwing money. This is it every day. Throw money at the problem. There's a lot of other ways to fix this. You could eliminate the inspections. You could. I mean, other people that are renting apartments don't have inspections. Why are the inspections required? You could, change the process by which the inspection doesn't necessarily have to occur before move-in. You could set it up so it has to occur within some time certain, 45 days after move-in. You could do a lot of things, but investing another $250,000, which is not a huge sum when it comes to the standards by which the state spends money, but it's still $250,000, $250,000 of taxpayer funds when people back home are struggling to pay their bills. I can't abide by just throwing money at problems. And that's what this is. This is throwing money at a problem. And to have 2 more inspectors, I do not think solves this. We offered the opportunity to maybe hire independent inspectors. You have home inspectors that are out there looking for work. There's not as many, home purchase transactions going on in Connecticut as in the past. So they're hungry for work. This is something they could easily do. That would be a lot more cost benefit, I think, than this. So I'm going to oppose this today, Mr. Chairman, but it is done with the fact that I support this RAP program and improving it if possible, but not at an additional expense that I don't believe is going to address the underlying issue. Thank you.
Thank you, Senator. Any other questions? Representative Weir.
Thank you for that, and I appreciate the issue that we have with the inspections taking so long, and that's limiting people from getting into their dwellings. But my issue is more with the process, as Senator Sampson mentioned, of just getting these buildings inspected in a timely manner. Does anybody have do we know how many current inspectors are employed doing this work statewide? Do we have a number?
That is a good question.
Am I answering or are you?
Do you have an answer?
No.
Then I can answer it. I do not have this at this time, but I definitely can get you the information.
I would have said the same thing.
Thank you, and I guess what would help me understand is, how many inspections are, how many inspections are performed for these RAP inspections annually versus the current head count of people. I can get you maybe a couple other questions, not to put you on the spot, but I want to know, if we've got 50 inspectors today, I don't know that to be true, and there's a backlog, and we're talking about adding 2. Anything is better, I guess, but is that really going to? So I think without that data, it's very hard for us to make an informed decision. And I agree with Senator Sampson that the process, there's things that we could do today, changing the process without adding any head count, any appropriations that would allow a little flexibility to the process that would get people in the homes today. So thank you for that. Look forward to information. I'll be a no today pending hearing more information, but thank you.
Yeah, and Representative, I actually want to highlight your comment on the capacity, because in other committees they are talking about whether or not we increase the amount of vouchers that we have here in the state, and an increase in RAP vouchers would mean an increase in participants and an increase in inspections when those years start. So it's a well-founded issue, and we can continue to talk about it. Any other questions or comments? Seeing none, vote will be taken by roll.
A motion has been made and seconded to JF2 appropriations, agenda item number 11, Senate Bill 152, an act appropriating funds for rental assistance program housing inspections. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
No.
Senator Sampson.
Sampson is no.
Representative Roberts.
Representative Roberts votes yes.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Senator Anwar votes yes.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockedale. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir. Representative Weir.
No, thank you.
Thank you. Representative Zulo. Representative Zulo. Thank you.
Thank you. On to House Bill 5261, the main event, I guess. An act permitting municipalities to prohibit rent increases in the event of multiple state building code violations. Do you have to the floor? Is there a motion?
So moved. Second.
Moved and seconded. This bill isn't terribly long. And it's intended to do exactly what it says, allowing municipalities to permitting municipalities to allow them to force a stay on rent increases if there are 2 or more violations of ordinances of the municipality relating to health and safety or the state building code until the violations are remedied. Is there any questions, comments, or discussion? I will just say, firstly, that this is not the final version of this bill, but we're not looking to pull any rabbits out of the hat. Just probably further flesh out and lay out what we're trying to do here in a way that's a little more descriptive. Questions, comments, discussions? Senator Sampson.
Thank you very much, Mr. Chairman. You weren't kidding. This is a pretty short bill. It just says any municipality may, by vote of its legislative body, adopt an ordinance to prohibit rent increases for any dwelling units that are subject to 2 or more violations of the ordinances of the municipality. Can I just ask some very basic questions? For example, does this apply to rent increases at the time of a rent renewal? Or is it supposed to imply that landlords are increasing rents during the term of a lease through you?
As you've pointed out, it's not a very long bill, but I would assume the intention is that while that unit is in that state, regardless of who's there, they should not increase the rent. Senator Sampson.
Thank you very much, Mr. Chairman. I'm not going to spend a lot of time on this because there's not a lot of time to spend. The fact of the matter is that there are solutions we've discussed already today. I put it back on the municipalities that have building inspectors, they have public health departments, they have fire marshals. They're the ones that are supposed to be making sure that if there are safety and health concerns with buildings, that they are rectified. They're the ones that are supposed to be holding these landlords accountable, and they have the ability to condemn a building, for crying out loud. I mean, you don't need this, okay? And the other aspect of this is that I think that it is going to have a very negative impact on some property owners that are trying to get ahead of a situation. Maybe the reason why the building is in disrepair is because they purchased a building, or over time they had many vacancies and the rents that they're collecting are below market. They don't have the ability to give the proper upkeep to the building. Maybe you have new management that's trying to resolve that situation, and they're trying to increase the rents to a point where they can actually maintain the property. This is just flies in the face of that. It's arbitrary, it's capricious, it shows the arrogance of government, frankly, by saying, it doesn't matter what the reasons are. It doesn't matter that there might be complete legitimacy to why a landlord might want to charge additional rent to improve the living conditions. It doesn't even require that the tenants are upset about it. What if all the tenants in the building got together and said, you know what, our building is falling apart. We'd all be willing to pay an extra $200 a month if the landlord was willing to improve the building. This would prohibit that. It makes no sense. It's just some arbitrary one random sentence from on high from government telling people how to live. It's not the way we should do things. If there's a genuine problem, let's find out what it is and let's address it. Let's not come up with just commandments from on high. Thank you, Mr. Chair.
Thank you, Senator. Any other questions, comments, or discussions? Representative Weir.
Thank you, Mr. Chair. I spoke with the speaker prior to session about this topic and local, and wasn't prepared for the language that I see here now. But I would like to be part of this process and talking about it was my and I agree absolutely with my colleague Senator Sampson. It was my I advocated to the speaker that the issue that I felt the issue was with a lot of these issues were at the local level and a lack of enforcement. And so, again, I'd like to be part of that discussion. What I conveyed isn't exactly what's here in the bill. This, as it's written, is problematic, but I think the intent is well intended. So I look forward to seeing this go forward. I'm a no today, but I think this, at least we have included the municipalities into the discussion and where I think a lot of this responsibility lies. Thank you.
Thank you, Representative, and we'll be sure to include you in the conversation. Any other questions, comments, or discussions? All right, main event time. Final roll call.
A motion has been made and seconded to JF to the floor. Agenda item number 12, House Bill 5261, an act permitting municipalities to prohibit rent increases in the event of multiple state building code violations. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott. No. Senator Sampson.
Sampson is no.
Representative Roberts. Yes. Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockadell. Representative Jensen. Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
And Representative Zullo. Thank you.
All right, this clock in front of me says 4:02. My phone says 4 o'clock, so I'm going to say we hold votes open until 5, and we will go in recess.
This isn't good.
Hi, Representative.
Hello.
Do you mind turning your camera on?
Oh, yes, I'm working on it. Camera.
Thank you.
So well run. And it is. I have. I haven't introduced myself. I'm Jack. Oh.
Hi, Senator.
Hello.
So I'll just go with you while Representative Jensen is working on his camera. So we had 12 roll call votes for the meeting today. Do you need the titles
No, I have them.
repeated? Okay,
Thank you.
cool. So we'll go with the agenda item number 15258.
Yes.
Okay, agenda item number 25259.
Yes.
Agenda item number 35360.
Yes.
Agenda item number 4336.
Yes.
Agenda item number 5339.
Annabelle, yes. Yes.
Agenda item number 65161.
Yes.
Agenda item number 75160.
Yes.
Agenda item number 85162.
Yes.
Agenda item number 95365.
Yes.
Agenda item number 105369.
Yes.
Agenda item number 15152.
Yes, please.
And then agenda item number 125261.
Yes, please.
Perfect. All right, then we are all set.
Thank you. Have a great
Thank you,
weekend.
Senator. Okay. Hi, Representative. Okay, so we only had you missing a couple. Let me just pull it up really quick for you.
Why is this so? Why is this so difficult?
Okay.
I have camera fail.
Yes. Okay, so it looks like I have you. So it looks like I lost you from agenda item number 3 down. Do you have the agenda in front of you?
I do.
Okay. Do you need me to say the titles then?
Here, let me go. So item 3, item concerning domestic violence and tenant screening.
Yep.
That's a no.
Okay.
Item 4, concerning housing. That's a no.
Okay.
Number 5, allowing long-term rental of bedrooms. That's a yes.
Okay.
Number 6, collection of identification for non-resident owners. That's a no.
Okay.
Number 7, appropriating funds to assist homeless. I'm going to say no.
Okay.
Number 8, amending an authorization of bonds for the Connecticut Housing Finance Authority. No.
Okay.
Number 9, increasing certain housing unit equivalents. Yes.
Okay.
Number 10, task force on the calculation of affordability and affordable housing. Yes.
Okay.
Oh, look, my camera's working. All right, number 11. Appropriating funds for rental assistance. No.
Okay.
And finally, number 12, permitting municipalities prohibit rent increases for multiple code violations is a no.
Okay, and then we are all set.
Okay, thank you.
Thank you, Representative.
Bye. Boy, that was freaking difficult. Mail. Mail.
How are you, Representative Zula?
I'm doing well, thank you.
Just give me 1 second just to collect what votes you missed.
Should just be the last two on the agenda.
All right, so for SB 152,
Rep. Zula votes no.
then for HB 5261.
Rep. Zula votes no.
Thank you very much, Representative.
Thank you very much. Have a good night.
You too.
Yeah, hi. This is Senator Anwar.
Hi, Senator. Can you just give me one moment just to get my bearings together?
Sure.
Thank you.
I was throughout the meeting. I'm surprised I missed a couple of votes.
Yeah, towards the end, we started moving a little bit quicker.
Okay.
No.
Item number 10 and 11.
Item number 10.
And then I missed his camera on 11, which was 5239. All right, just showing a little market out here. Just have to do this.
Great. So for item number, how do you vote?
Senator Anwar votes yes.
Great. Then also 11.
Yeah, we'll just mark it. 11.
Senator Anwar votes yes for 11.
All right. And then for item number 12, how do you vote, Senator?
I already voted for that, but I'll vote again. Senator Anwar votes yes.
All right. Thank you so much, Senator. Have a good one.
Perfect.
Hello?
How are you, Senator?
I'm well. Time to vote?
Yes. Yep. So we voted on 12 items today. Would you like me to read off the titles of
Nope. I'm a yes for all of them.
for all of them? All right. Thank you so much, Senator.
All right, thank you.
Have a good one. How are you, Senator?
I am doing well, and yourself?
I'm doing well. So we had 12 items to vote on today. Did you want me to read off the titles for you?
I do know that I want to vote consistently with the chairs, but yeah, you can read them all for me.
Okay. So HB 5258, and that concerning tenant organizational activities.
Yes.
HB 5259, an act concerning the education of homeless children and youth.
Yes.
Great. HB 5360, an act concerning domestic violence and tenant screening.
Could you talk to me a little bit about what that bill is?
Give me 1 second, please.
Well, first, if the chairs voted for it, yeah, then I'll say yes to it.
All right. So yes, both the chairs voted yay on that.
Yes.
All right. Right. SB 336, an act concerning housing.
Yes.
Right. SB 339, an act allowing long-term rental of bedrooms in a single-family home as of right.
Yes.
Right, HB 5161, an act requiring the collection of identifying information of non-resident owners of residential property.
Read that one again.
That was 5161, an act requiring the collection of identifying information of non-resident owners of residential property.
Yes.
HB 5160, an act appropriating funds to assist homeless persons.
Yes.
HB 5162, an act amending an authorization of bonds for the Connecticut Housing Finance Authority.
Yes.
Right. HB 5365, an act increasing certain housing unit equivalent points.
Yes.
SB 152, an act appropriating funds for rental assistance program.
Absolutely 5 thumbs up.
Right, and then the last one is going to be HB 5261, an act permitting municipalities to prohibit rent increases in the event of multiple state building code violations.
Yes.
And you're all set, Senator. Thank you so much.
All right, thank you. All right, bye-bye now.